the important issue also is that these companies take on are the limited liability, so that the owners, in terms of the people who own their shares in the company, will be liable only to the amount of shares or the value of the shares or the guarantee that they provide for the shares that they own, if and when the company ceases to operate. And for example, if the company ceases to operate because it cannot pay its debt. Other feature is that these shares are transferable. So even though there are some restriction on the transferability, they are nevertheless transferable. So the regulations will be there on whether or not it is a sole trader or sole proprietorship, whether it's a partnership or a partnership which is limited by witness through a solicitor, although, in which case, of course, the individuals or partners are individually and severally liable. What has come to light is that in the Philippines, for example, the limited partners actually have only limited liability and not total liability. Because in the event of the one partner, even if it is called a limited partnership in the UK, disappears and the company is indebted, then whichever partners remain are also responsible for those debts. Not that they were in debt by 20% or 10%. The 50% that disappears now becomes the liability of the remaining partner or partners. And so the limitation in liability in the UK for partnership is simply to suggest that whilst all the partners are present and none has absconded or none is deceased, then the liability will be shared in proportion to the original agreement. That profit will be shared per original agreement as stipulated in that limited liability documentation. Whether or not, of course, there's going to be centralized management, and that this centralized management can decentralize. However, there is a board, and that this board has significance in terms of how the company operates or the corporation functions. Historically, and we still have some organization boasting of their royal charter, although the old companies such as Lloyd's of London are not limited by liability, and so they also are individually and severally liable. And I'm trying to remember if it was Katharina that brought them down. And so we found that a number of prominent people, including ex-boxers, who were very, very wealthy, were brought really down to earth, where they had even their position, their medals had to be sold in order to fund what the losses that they had incurred. There's a lot of regulation, quite a lot of regulation, surrounding how the companies should operate, how they should be regulated, what documentation they should produce. So even this morning, much of the news was about the care homes, and the care homes have been going bust and leaving the vulnerable people at risk. And we say there needs to be more transparency. there needs to be more regulation in order to ensure that they don't go into receivership. They can be rescued. One of the classic things in this type of corporate governance is that directors can award themselves very huge amount of remuneration. They can give dividends or sharehold or bonuses even when the company is at loss. This is a financial institution lending the money, and these people take the money. Soon after they award themselves bonuses, then the companies will go into receivership. Then some of these need to be taken back. And of course we have heard the sign of, I think, it may have been Lloyd's chief executive, which is being asked to pay. Great, thank you very much. Because they go with that money. It means that the company owes that money and has to find it, because if they make a loss, I can't understand. If they make a loss, how on earth can they get a bonus? But they get a bonus on the transaction, not the value of the transaction. And this is why part of the regulation which we are trying to bring in, or the government might be a bit timid to bring in, is that this should be on a long-term basis. If you're going to give performance-related pay, bonuses, then you should wait until the end of the period that the transaction relates to. So you know that you have collected all the money and that you're okay. Not that you have sold equities, but that all these equities relate to something tangible. And this can only be justified by the result that it is achieved over a period of time, rather than instantaneously. So we're looking at the laws, we're looking at the regulations, we're looking at the generally accepted business practices. We're looking at accounting systems and what type of accounting systems are used. We're looking at audit and whether or not auditors follow the trails and try to check whether or not all the transactions and all the claims are justified. Whether or not simple things such as whether or not the government stipulation as to how company vehicles should be allocated and managed and operated, whether or not these are put into force, whether or not the current mileage allowance is given to people, or whether or not they're given over the odds, whether or not the companies have been meeting, and whether or not the correct forms, the correct authorization is given for the different transactions. For example, whether they're in terms of awarding dividends to themselves, whether or not these have had in fact been documented.
That is why now in the US there's more emphasis on independent directors.
Yeah.
But they don't get dividend.
Yes.
So they will make sure that whatever is done is in the interest of the stakeholders.
That's great. That's great. And so some elements of corporate governance then is actually suggesting that shareholders should have a say in how much award directors get. In our case, ordinary shareholders will have a vote at annual general meetings wherein members of the board will be elected and deselected. And whether or not pay comes into the equation, then they should also determine the level of directors' pay.
Yeah, but the problem is, the way I see it here is, it's non-binding.
Yeah.
It's just advisory.
Yeah.
And so it's not very effective. I have seen a case where shareholders voted against the decision of the remuneration committee at in AGM. And normally it's after the fact. They had already paid the CEO the bonuses, and then it was brought for ratification, even though they voted 54% against 46. I could say already the damage has been done. So perhaps, well, it's good because you started it here for shareholders to have a say, but perhaps in the future they will be more aggressive and ensure that the directors take cognizance that they may be challenged by shareholders at AGM.
Yeah. I think one of the problems that we have is the weight of the ownership, and therefore the weight of the votes. Because where we have institutional shareholders, then they are giant and they would command so much percent of the vote. And if they support the remuneration, then the ordinary shareholders who are individuals, they can't do very much by themselves.
Yeah, but there's a case where even the institutional investors voted against the decision of the board. So, but again, since it was only advisory, the effect was not really much. But I think it's good. We are beginning to encourage shareholders to voice their opinion regarding how the CEOs are compensated. We looked at a case at Harvard University where the CEO of the New York Stock Exchange left with $189 million compensation. And the worst part of it was that part of the compensation, which was supposed to be after retirement, was paid to him while he was still the operating officer. He was involved in deciding who would be a member of the remuneration committee. So you see the corporate governance issue.
Yes.
He was also playing a role on who becomes a director and who leaves.
Yes.
So these are corporate governance issues that really, of course, the chairman of the committee had to leave. Then almost all the directors had to leave, and we saw it as gross abuse of corporate governance.
Thank you very much. I think in terms of institutional shareholders, I think what they might not realize or might not have thought about or not thinking about is the fact that they can dispose of their shares or threaten to dispose of their shares. And if they start doing that, then of course the value on the stock exchange goes down. And the companies will definitely have to take cognizance of the fact that they are weighty and rely on them for their strategic direction. So one of the concerns is that a corporate government should promote some level of transparency. And the transparency we were talking about this morning, which has been highlighted in the news, is in particular relation to the care homes in the UK. That I think it was a private equity which bought a large, I'm not going to name the home now, but a large care home establishment that I think it was about, in one area, about 90% of the care was given by that company. And that company goes into receivership. Now, the reason that this is significant is that the nature of private equity is that they take over, then they asset strip.
Yeah.
Then they leave that little bit of organization to run itself, and they expect it to run at a profit. At any given time, they will dispose of that asset and they will make remaining profit. So in the first place, they would have repaid all the finances that they had been given.
Yeah.
They would have paid themselves handsomely, and they can easily walk away. Rather than walking away, they leave it to function as a slimmed down version of its previous existence. That's one of the basic problems with them. And therefore, in the UK, we have quite a number of problems with them. In the United States, there is also a great deal of problems. However, as I said earlier, legislation has not been able to affect them because of the consequence that this would have. They would have to take them out, and it would be difficult to take them out singly and legislate. They would have to legislate around them, hoping it will affect them. And if it affects them, then it will affect similarly small businesses. They are not small businesses by the time the number of or the value of the equity that they have in the various establishments. But in fact, they have got quite a lot of money. They have quite a lot of resources. They have got access to further other resources, etc. So the board, we expect to supervise. We're looking at the German model, where they have a two-tier, so that shareholders and employees would be on and of course I think we have this somewhere in South America, where we have this two-tier board, and where employees actually have a significant role, a significant weight in the appointment of directors and the remuneration of directors.
Okay.
And here we have the option in France and companies which are incorporated in Europe. Societas. What's the balance of power between the board of directors and the other members of the organization? So those are at the lower level. So in true corporate governance style, we actually try to make this distinction, and we try to balance. Again, the annual general meeting is a time when shareholders, ordinary shareholders, get a chance. If possible, if they can, at least they have a vote, and if they understand or have time to understand what is actually going on in the boardroom, then they would be in a better position to vote in a particular way. Again, when there needs to be amendments to all the documentations, or the documentation relating to their incorporation, then this has to be made, and this has to be recorded, and this has to be sent to Companies House. Companies House is the place, or it is the department of the business, Department for Business and BIS, Business Information and Skills Directorate, where all companies are registered and that the registration and documentation of companies are recorded and held. And the whole reason for all this documentation is to promote transparency. And so we have, for example, the annual report. The annual reports has to be taken. There's a penalty for the directors if annual reports are not made within, I think you have about 1 month from the end of the year, the company year. And of course, the accounts have to report it as well, excepting, and the accounts will be reported in full, excepting abbreviated accounts for small companies, and small companies in relation to whether or not it's on one of two of three bases. One is the balance sheet, two, the number of employees which it has, and three will relate to their turnover. And so this changes from 1 year to another. We're thinking in terms of having a company with a high level of integrity, one that has a very high reputation, one that does not abuse power. We're thinking in terms of true business ethics. We're thinking in terms of one that is reliant on the compliant with the regulations, general regulations. And one of the things is, it is important for companies to stay alive. Stay alive because these are the sources of employment for the people. These are elements of the economy, so that corporation taxes cannot be taken from the company or cannot be required from the company if it doesn't make a profit. And this is one of the things which is required of the new international financial reporting standards, that here we have the auditors. The auditor has a right and is required to look at how the company operates and whether or not, for example, the company is making very good use of information systems. If it is not making very good use of this, then this should be brought to their attention. Recommendation. So if they look at the way the company is operating from a profit base, from an integrity base, from a transparency base, it needs to make these recommendations. And so, when we look at the Sebens-Oakley's Act, the Sebens-Oakley Act is saying that all auditors now have an obligation, if they are dealing with United States companies, whether operating in the United States or having a subsidiary elsewhere, then they are going to be brought to law if they are not reporting the things that they see. They need to put these in writing, and they need to table these as concerned. And this came about particularly, and we will see when we look at the financial SEC, Securities and Exchange Commission, and the review that they have taken as a result of the failures from Enron, Madoff, and all the others, the Ponzi scheme and others, that these are serious matters, because if the people, the shareholders, are defrauded, if the investors are defrauded, no profit is made, No money is generated by these people. These monies are amassed by a very few people fraudulently. So even if they go to prison for life, then this does not help, because where are the resources? Unless, of course, we have all the assets, seized, and that these people are made to get compensation for their losses. So we will have a look at the the SEC operation
Okay.
in a minute. Yeah. So thank you very much.